Welcome to today's program titled A Special Multi-Part Series on State and Local Paid Sick Leave Laws, Part 9, Unions and Leave Requirements, examining how the patchwork of paid sick leave laws impacts collective bargaining under the RLA and NLRA. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Ada Dolph. Ada, please go ahead.
Thank you. Good afternoon, everyone, and welcome to our Unions and Leave Requirements presentation. Presenting today, we have Josh Seidman, who's a partner in our New York office and who has devoted his legal career to understanding leave, believe it or not. And then we also have Jason Silver, who's an associate in our New York office and a member of the firm's traditional labor group. And I'm a partner in the Chicago office. I'm also co-lead of the air and rail specialty team with Molly Gable. And there's information on all of these groups at the end of this presentation. And with that, we can go to the next slide. So Josh is going to talk about national leave law, paid sick leave law treatment, and impact and analysis of PSL laws, paid sick leave law treatment. And then it turns to Jason at number 3, impact and analysis of PSL laws on NLRA compliance. And then I'll be talking about the air and rail piece, which is number 4, and the resources are at the end. And with that, I will turn it over to Josh.
Awesome. Thank you, Ada. Hello, everyone. Thank you so much for joining us for today's part 9 of our paid sick leave webinar series. Been doing this for about 2 years now, and it's really amazing that it sort of keep coming, lots of topics to keep presenting on. We're really happy for you all to be joining us today. As you'll see on the next slide, I'm going to get us going with our national leave law overview. There's a ton of leave requirements that you'll be dealing with at sort of a state, local level. And you'll see, if you go 2 slides from here, you'll see sort of the initial overview of what some of those laws look like. All right, so I'm going to just get us going, and the slides will catch up to us. So in terms of the overview, right, the national leave law overview, we have a number of different topics. We have, perfect, just go 1 more slide from here and we'll see the overview for me. So to start us, we have the paid sick leave law world, which I'm not going to spend too much time speaking about on this particular slide. We're going to get into the weeds over really the next 20-25 minutes or so. But at a very high level, what these laws are, they require employers to provide a certain amount of paid leave to their eligible employees based on their hours worked for certain covered reasons, and those reasons can include being sick themselves or a family member who needs to be cared for, preventative care, and a number of other covered reasons. Now, some other laws that are out there in the leave world, very big one that gets a lot of attention are paid and unpaid family medical leave laws. And you have the federal FMLA, which folks are aware of. It's almost 30 years old. The FMLA is turning 30 this February. A lot of big deal there. That provides unpaid family medical leave to eligible employees. But you also have a ton of paid family leave laws that have popped up around the country. There's 11 states plus Washington, D.C. and San Francisco that have paid family leave or paid family medical leave laws, that second bullet point. Now, what these laws are laws that require employers to provide employees or through some type of program, an insurance type of program, with either paid or unpaid leave for a variety of covered reasons, including bonding with a new child, caring for a family member with a serious health condition, among other reasons. Now, we have a whole separate webinar series on paid family leave and paid family medical leave, so I'm not going to drill into the nuances of these laws because there are way too many to get into today. However, I will say that a number of paid family leave laws do apply to union employees. And I think it is somewhat common for employers, just like in the sick leave context, but especially even more so in the family leave context, to assume that because I have a negotiated CBA between the company and the union on the one hand, and this insurance-driven program, especially with the paid family leave world, on the other hand, that union employees don't really get this benefit, and that is sort of a misnomer. And at least a handful of these laws, a number of the laws will not apply to a CBA if it's in effect as of the effective date of the paid family medical leave law, but will, upon reopening or renegotiation, then cover those unionized workers. And that's something you'll hear about in the sick leave context as well. Places like Washington State and Washington, D.C. fall into that example with their PFL programs. Some other laws require the CBA to provide benefits that are at least as favorable as certain criteria within the paid family leave law. And New York is a good example of that. And then you have the two newest laws in the paid family leave context in Delaware and Maryland saying that a CBA is not allowed to circumvent those paid family leave laws. So important to just keep that in mind, that even though you have the CBA, these paid family leave laws could still apply. Other types of laws in the leave space, we have temporary disability insurance laws, right? Laws that provide partial wage replacement benefits to employees who are temporarily disabled or unable to work because of a non-work related illness or accident, very related to the paid family leave laws in the prior bullet point. You have safe time laws. These are laws that cover absences related to domestic violence victim status for the employee or their family member. Provide paid or unpaid leave for a certain number of days for covered reasons related to that victim status. Bereavement leave laws, laws that provide time off for certain absences related to the death of a covered family member. These laws, although not as widespread as the first four bullet points, getting a lot of attention lately because California just passed a statewide bereavement leave law a few months ago at the end of its state legislative session. You have workers' compensation laws, right, that allow employees to receive no-fault compensation for accidents or illnesses that are work-related, and then unemployment benefits to round out the points on this slide. If this wasn't enough, there are so many other state and local leave patchworks around the country. I'm not going to read the list that I have here sort of for you all, but know that there are a ton of others. We're talking, between 15 and 20 at least other categories of these leave laws that when you're an employer and you're dealing with negotiating a CBA and having a meeting of the minds, coming to a sort of a middle ground with the union on these various leave and time off benefits, once you do the hard work of finding something that the sides can agree on, don't forget about all the various leave and time off laws that can also muddy up the playing field, because there are a lot of them and there are many patchworks around the country at the state and local level. Next slide, please. All right, so turning our attention to the focus of today, which is paid sick leave. Now, why are we picking paid sick leave sort of out of that lineup that you saw on the last slide and talking about it in more detail today? Well, one, there are a ton of these laws around the country. But number two, paid sick leave has gained a lot of attention in the media over the last several months, 3, 6, 12 months, in particular with respect to these rail labor negotiations. There's news as of just a couple of hours ago coming out of the House of Representatives and them passing a bill to try to avert a strike dealing with the rail labor union. So a lot of sort of moving pieces with respect to these negotiations, but the divide between the two sides, between the companies and the unions, is paid sick leave and attendance policies, right? That is the reason why sick leave has become such a hot topic. Not only are these laws proliferating all over the place at the state and local level, but they're also gaining national attention in this CBA unionized space. So give you a little bit of background about what the paid sick leave world looks like. We have a total of 63 laws today around the country. Now, that is not just necessarily paid sick leave. That can be paid sick leave, paid sick and safe time laws. A lot of laws will cover safe time, as I explained it on the last slide. These can also be, there are a handful of PTO or paid personal time laws that get counted here, like in Maine and Nevada. Also, a ton of COVID-related paid leave laws that have come and gone over the last almost 3 years since COVID became a thing. And you also have more recently replacing some of these COVID leave laws, public health emergency leave laws. And when you put all that together and you do some math, which, adding federal plus the states and DC plus the 26 municipalities, that lands you right in the mid 40s, not at 63. The reason for the jump is because a number of locations, California, New York, Seattle, San Francisco, New York City, Chicago, have multiple of these types of air quote paid sick leave laws in place today as it stands. So a lot of the laws will have 2, maybe even 3 of these mandates, and that gets you to that total number, which is constantly changing. It's ebbed and flowed in the low to mid to high 60s as a result of COVID paid leave laws coming and going since the mandate, since COVID began. Next slide, please. This slide is just another way of representing the messiness of the paid sick leave world. You can see this is almost 2 years old, this slide, and we're working on an updated version with our leave of absence management team. But in the interim, 2021, you can see all the different colors representing different combinations of COVID, non-COVID sick laws, state and local laws, paid sick leave and PTO laws, and the like. And also that turquoise color being something that we don't really dive into today, but state laws that prohibit localities from passing paid sick leave laws, which we call anti-local sick leave laws. There will be updates to this, Matt. Virginia has a statewide law that applies only to home health care workers. There's a new statewide law in New Mexico that came out just a couple of months ago. New local laws in Pennsylvania and California, among many COVID laws coming and going. So this chart will be updated, but again, shows you how messy the patchwork was 2 years ago. Next slide, please. All right, so let's turn our attention to paid sick leave and its impact on CBAs and unionized workers. We're going to start you all off with a quick polling question. So no right or wrong answers here. If you would be so inclined to participate, you should see on your WebEx slide a graphic there that there's a pop-up on the right side for you. You can pick one of these answers. The choices, let me read this out to you. So if your organization has unionized employees, which I assume a lot of you do, given today's presentation, how does the CBA currently account for state and local paid sick leave laws? Does it, number 1, provide the required benefits? Number 2, have jurisdiction-specific carve-outs or MOUs, side letters, and the like? Number 3, does it waive the paid sick leave requirements from the state or local law? Number 4, does it depend on the jurisdiction in question? So maybe you have a waiver in one place, but a carve-out or MOU in the other place. And then number 5, you're not really sure, you're not even necessarily sure what a paid sick leave law is. And I'll tell you, as we start to focus on these laws and their various requirements, you'll realize that as with many other paid sick leave topics, right, the answer will vary. It will depend on the jurisdiction in question. And that it should be no sort of surprise to folks. So thank you, everyone who did participate. We have A, providing the required benefits sort of being the biggest answer there, and then D, right, depending on the jurisdiction, coming in second. And D really is sort of the answer, and that can be the answer for a lot of topics in the paid sick leave space. Let's go to the next slide, please. Thanks again for everyone who participated. So when we think about how paid sick leave laws impact CBAs and unionized workers, there are 3 main categories of treatment to discuss. Number 1, no waiver, no exemption permitted. Gotta comply. That's sort of that first of the choices that you saw on the last slide. Number 2, there's a waiver allowed, but something needs to be done, right? There are certain conditions that have to be met. Number 3, union workers are excluded from the law. Now, it should come as no surprise that there are variations within both, number 1, how you sort of get to the no waiver, no exemption permitted through the particular law, and number 2, what those conditions look like if the law does allow for a waiver or an exemption. This is just like, again, if you think about other paid sick leave topics, right? How much time do workers get to accrue? Well, some say 40 hours per year. Some say there's no cap on accrual, right? Some say you accrue based up to a maximum balance cap. Some laws will say when you're thinking about how much time can workers use per year, that will vary as low as 3 days per year, all the way up to there's no limit on the amount of available time that workers can use. Same thing with year end. What happens to unused time at year end? Do I forfeit it? Do I roll it over? Do I pay it out? Those things all have variations depending on what particular law we're talking about. There can be variations within a state versus from the state to the local law. And then you start looking at all the other conditions of the sick leave laws, the reasons for use and family members, treatment of new hires, increments of use, waiting periods, rates of pay, notice from employees to the company for planned and unplanned absences, and documentation, and so on. And all of those topics will depend on what location we're talking about. Treatment of sick leave law, how sick leave laws treat CBAs is no different. So let's go to the next slide and drill down a little bit further on what some of these differences look like. So for starters, the no waiver, no exemption slide, right? This is where the law basically says, hey, company, you got to comply. Doesn't matter if you have a CBA. The parties need to come together and figure out a way to get these benefits to their employees, to the constituents. How we get to the no waiver, no exemption, like I mentioned, will differ depending on the particular law. There are some paid sick leave laws that are just straight up silent on CBAs, right? That do not address the topic, meaning that there is sort of no end around, no option for employers to avoid the requirements. Places like Massachusetts, the city of Los Angeles for its general paid sick leave law rather than its hotel worker specific paid sick leave law fall into that category. There are some laws that will permit an initial sort of timeliness waiver. If the CBA predates a certain date, like the effective date of the law, for example, then you don't have to comply right away. But after that buffer period ends, full compliance is required. Plenty of locations on this list fall into that category. Connecticut, Maine with its paid personal time law, Michigan, Seattle, the federal contractor, Executive Order 13706 that requires employers to provide paid sick leave to certain employees who work on or in connection with a covered contract or subcontract, right? All fall into that category. Then you have some laws that will say, okay, your CBA has to provide equivalent or greater paid sick leave or paid time off benefits in order to get the waiver or exemption. And what we sort of take that to mean is that really isn't a waiver, right? That is the law saying you've got to comply. Colorado, for example, says equivalent or more generous. And we're going to talk about Colorado again in a few slides to drill down on that point. San Diego and Rhode Island use the phrase greater paid time off. Montgomery County in Maryland uses the phrase the CBA needs to provide paid leave benefits that meet the minimum requirements of the law. Minneapolis, very similar, minimum amounts and conditions of use for paid sick leave. The Nevada PTO law, right, talks about the CBA offering leave that matches or exceeds the requirements of the law. You get the point. So a lot of these laws will say, even though it masquerades as a possible waiver or exemption, there really isn't one when you think about it, because it says you've got to meet or exceed the requirements of the law. And as I mentioned at the start of this slide, there are a lot of requirements. It's not just the right amount. It's the right reasons. It's the right conditions. Next slide, please. All right, so now we get to our next topic, category number 2, waivers. Again, variations. So you have some jurisdictions that have a permit sort of a full-blown waiver of the paid sick leave requirements, and New Jersey falls into that bucket. I'm not going to talk about New Jersey any further because Jason will be giving you some more detail on New Jersey in just a few minutes, so I don't want to play spoiler too much for you there. Next topic, industry-specific waivers, right? We have waivers for the construction industry in places like Maryland, California, Chicago, assuming that there is sort of an express waiver that's entered into in a lot of cases. New York City, right, will exempt certain grocery employees with an express waiver in place. Then you have that timeliness waiver that I mentioned. Again, the CBA needing to predate a certain date in order to take advantage of that one-time waiver. And then once the CBA gets renegotiated, the timeline for the CBA, the timing terminates, it's reopened, then certain other things might happen. You need to go and get another type of waiver, as we'll talk about. You have waivers that are allowed as long as the parties agree in clear and unambiguous terms to the waiver in writing, memorialized in the CBA or a signed letter. You also can have waivers or exemptions that are permitted assuming the CBA guarantees a certain level of paid leave benefits, comparable benefits, equivalent benefits, things like that. And we'll talk more about those in a few slides. New York, New Mexico, Washington, D.C. being some examples there. And then finally, you have exemptions and waivers that are allowed if the CBA or conditions related to the CBA are met, right? And that you can see in places like California and Oregon. And we'll also talk about both of those in just a little bit more detail as well. All right, next slide, please. So let's focus on sort of the most pro-employer of these waivers. That is the clear and unambiguous waiver topic. Now, some laws will also say instead of clear and unambiguous, you need to expressly waive the law. We've included those laws on this slide just for completeness. So sort of either clear and unambiguous waiver or an express waiver is what you're seeing here. A decent number of states, although some that have sort of limitations for the particular industry. A good number of localities that allow clear or unambiguous and unambiguous waivers to get out from underneath the paid sick leave requirements. A lot of them, as you can see, coming from California, which is home to the greatest number of localities with a paid sick leave mandate. You can see a good number of the localities with a non-COVID paid sick leave law do allow employers to get around the sick leave requirements via a clear and unambiguous waiver. If you don't, though, right? San Diego does not. The general paid sick leave law in LA does not. Just a couple of examples. A few more points on this slide. Number one, you can see a place like New York City does sort of allow an express waiver, calls for one, but there also has to be something more, something comparable. And we'll talk about that term quite a bit over the next several minutes. Seattle had one of these waivers allowed, but it had a timestamp on it. It sunset several years ago. So we've included Seattle here for nostalgia purposes, but there really isn't a clear and unambiguous waiver option in Seattle today. Seattle was included a couple of slides ago on that list of places that doesn't really allow any type of end around of the paid sick leave requirements via a CBA. So that's this slide. Again, the most pro-employer of the waiver options. Next slide, please. All right, so a lot to dive into on this slide. These are a few examples of this sort of sufficiency language, as we've called it. The CBA needs to meet a certain standard, provide a certain level of benefits to sufficiently get out from underneath the sick leave law requirements. Let's go through a few of these. New York State, New York City, great example. You can see on the slide here, they call for an express waiver. Right, New York State requires an explicit reference to the statute, and then this term again that I mentioned, comparable benefits. And we'll hear more from Jason about what comparable means, the various interpretations of that term, some broad, some more narrow and strict, with not the best guidance out there in terms of which way to go, in terms of the more broader reading or the more narrow reading. Colorado, right? As I mentioned a few slides ago, says it doesn't apply if the employer provides through the CBA equivalent or more generous benefits. Well, we know what more generous means, right? That's greater than, right, than the sick leave law. But what about equivalent? Does equivalent mean equal? Does it mean close to, mostly? If it is close to or mostly, what are the conditions that need to be met, and what are the ones where we can sort of cut some corners? Well, Colorado, to its credit, provides some guidance on this particular topic. And it says, and I'm going to read this out to you folks, equivalent or more generous paid sick leave means the CBA does not diminish any employee protections under the law or the rules, including but not limited to accrual, carryover, use, the conditions of use like documentation and notice to employers, protection and effectuation of sick leave rights by giving notice to employees, protections against retaliation, protections against interference, and so on. So what does it mean? What does the term equivalent mean? Well, it sounds like it pretty much means equal here, that there really isn't a true sort of waiver in Colorado, as I mentioned a couple of slides ago. Now, let's look at New Mexico by comparison, right? The New Mexico standard, and this again is the newest of the statewide paid sick leave laws, just came out a couple of months ago in July. This standard is very common, whether union or non-union, for PTO policies that are seeking to comply with sick leave laws, right? That the CBA doesn't have to provide additional sick leave to members, union employees that are covered by the CBA if provides sufficient accrual and use of paid time off, and that paid time off can be used for the same purposes and under the same terms and conditions as sick leave in New Mexico. That's a very high bar to meet, right? Same purposes typically means the same reasons. Terms and conditions of use are all those things I mentioned a few minutes ago: rates of pay, treatment of new hires, increments of use, and so on. Really high bar in New Mexico, and some of the newer sick leave laws, like the home health care paid sick leave law in Virginia, like the Allegheny County, Pennsylvania law, like the Bloomington, New Mexico law, have the same standard in terms of CBAs and how the sick leave law handles CBAs and union workers' entitlement to the sick leave benefits. Finally, Duluth, Minnesota on this slide, just to round out, you can see the standard is a substantially equivalent standard, right? Well, if equivalent meant equal, right, in Colorado, substantially equivalent, does that mean more than equal? Does that mean almost, mostly equal, right? Not as much guidance there. But what a big takeaway from this slide should be for you all is that outside of New York City, all these laws are new. They've all come out since 2020. Duluth was in early 2020. The rest, New York State, Colorado, were in 2021. New Mexico earlier this year. Allegheny County, Virginia, Bloomington, Minnesota, all new laws. None of them have the clear and unambiguous waiver standard that I mentioned a few slides ago. They all are requiring more of employers and unions. They want workers who are unionized to receive, whether it's the full scope of benefits or something close to comparable, equivalent, right? They want workers to receive paid sick leave benefits that are within the spirit and maybe even the full letter of the law. And that's bad news for employers with unionized workers, because that means more legwork needs to happen during negotiations. There is no sort of shortcut, clear and unambiguous waiver under a lot of these newer state and local laws. Next slide, please. Okay, California and Oregon. I'm not going to read the full California standard to you. Needless to say, it's pretty burdensome, right? There is an exemption that's allowed, but only if certain conditions are met, providing the wages and hours of work and working conditions within the CBA. That's pretty common. A couple of things that aren't necessarily as common: final and binding arbitration, right, with respect to disputes concerning the application of this California sick time provisions, and providing a regular hourly rate of pay that is not less than 30% more than the state minimum wage rate, right? Those are some things that are less common in CBAs that are required in order to get out from underneath the state sick leave law requirements. The Oregon sick leave law doesn't apply to employees whose terms and conditions of employment are covered by a CBA. So far, so good. But then B and C make this a much more narrow exemption, right? The employee needs to be employed through a hiring hall or a similar referral system operated by the labor organization or a third party, and the employee's employment-related benefits need to be provided by a joint multi-employer employee trust or benefit plan. So really, in practice, that means for most employers and their unionized workers, Oregon does not provide a true exemption and end around of the paid sick leave requirements. Next slide, please. All right, timeliness waivers. We mentioned these already a few times. Hopefully you get the concept. This is here to show you where a lot of these waivers did operate and exist. These are Band-Aids. These are, in many cases, waivers that give the employer a buffer, sort of a break from compliance for a period of time if its CBA predated the relevant date, the relevant effective date, or the other date that the law sets. But that is not a full-blown waiver. Then the employer might need to do some additional legwork, provide comparable benefits, go and get a clear and unambiguous waiver, and so forth. Next slide, please. All right, the final category, union workers not covered by the law. Philadelphia is sort of the lone law that meets this standard. But again, remember, the clear and unambiguous or express waiver category from category number 2, that's the lowest bar that we're going to come across, the most pro-employer in terms of avoiding the sick leave requirements for its union workers. So even though that is not sort of a full-blown, this law does not apply to union workers, it is, again, a low enough threshold that assuming the company and the union don't have completely sort of unfriendly terms that you can get to the table and negotiate over something like that, usually companies can get that type of waiver in place and then go back to just dealing with the union on sick leave and that term of employment. All right, next slide, please. So last one for me before I turn it over to Jason, attendance policies. Mentioned at the start of my section how important not just sick leave, but also attendance policies are and have been in the rail labor negotiations over the last several months. Very important in the sick leave context, right? Not disciplining employees, whether it's through occurrences or points or some other form of discipline under an attendance policy, even if it's a last minute call out, is part of sick leave law compliance. Right? Many laws expressly prohibit attendance policies from doing just that, from counting foreseeable or unforeseeable absences as occurrences or receiving any other type of discipline. All but one or two paid sick leave laws go even a step further and just have these broad sweeping anti-retaliation, anti-interference protections. So when you're drafting and working through attendance policies during negotiations over a CBA, making sure that those policies and those articles account for, right, protected sick leave absences, assuming there is no waiver in place, as well as other terms and conditions and criteria of the sick leave law, notice to the company, documentation, and so forth. Making sure that all the I's are dotted and T's are crossed for sick leave compliance becomes really important, especially going forward, because a lot of unions and their members, after hearing about sick leave and attendance policies for weeks and weeks during these rail labor negotiations, are going to focus on them for upcoming negotiations. So with that, I'm going to turn it over to Jason to talk us through the impact of sick leave laws generally on the NLRA and compliance.
Thanks, Josh. Appreciate it. And we're going to discuss some issues that complicate sick leave laws, some common conflicts that we see between these paid sick leave laws and what we normally see in CBAs, go through the steps we should be thinking about to ascertain how to get into compliance, and look at how compliance plays out, particularly in New York and New Jersey, where I have experience in this area, and then discuss some best practices. Next slide, please. So because CBAs memorialize the pertinent terms and conditions of employment, most CBAs provide for paid sick leave in some form. It could be one bank of paid days off to be used for a variety of reasons, or it could be separate banks for sick days, personal days, vacation, and the like. And from an NLRA compliance perspective, we generally deal with what's called mandatory and permissive subjects of bargaining. And mandatory subjects of bargaining are those that vitally affect wages, hours, and terms and conditions of employment. And as you can see up there, that includes sick days and paid time off. So that means that when we deal with this issue as it relates to a potential change with our employees represented by unions, we have to provide the union with notice and an opportunity to bargain over the issue before any change is made. We also have an obligation to respond to information requests related not only to the amount of leave that we provide, but also related to the mechanisms and procedure for how that leave is administered. Next slide, please. So two main issues from a CBA perspective with regard to dealing with these laws. And the first is, are you providing the amount of time called for in the law? And in my experience, in a lot of instances, employers are. But there's also this question of whether the procedure and mechanisms required by the law as it relates to the administration of the leave are being followed. And both of these issues can impact the economics, right, if you're not providing the requisite amount of days. But it also can impact how you normally administer paid leave in terms of accrual of days, types of usage, notice, documentation, and the use of an attendance system, and require changes to those aspects. And as Josh mentioned, if you have an attendance-based system in your CBA and there's a sick law that you have to follow, you need to ensure that you're not deducting points to any employee for something that would be permissible, a permissible absence under the law, but maybe not a permissible absence under the CBA. So, and I think that the biggest issue with these laws from a unionized workforce perspective is that it interferes and complicates the labor relations relationship. In a lot of instances, the parties have for years been bargaining back and forth, coming to agreement over a collective bargaining agreement, arriving at a final package that for the most part, and normally takes into account this particular issue. With the implementation of these laws, there's now a question of whether, is there a cost to an employer, either economic or non-economic, to come into compliance? And if there is, I imagine an employer is going to want to contemplate whether they want to try and recoup that cost in some way, shape, or form in other areas of the CBA. And that impacts the relationship between the employer and the union, the employer and the employees, and the union and the employees, because it potentially requires changes to something that the parties may have come to a different agreement on. Next slide, please. So what we've done here is list some of the substantive criteria that employers must comply with under a paid sick leave law, which highlights kind of the conflict between what those laws provide and what we normally see in CBAs. More often than not, the various different reasons, one of them, the first one being the reasons for use. More often than not, the various different reasons and ways an employee could use the leave are often much broader in these laws than what's required under a CBA. It's not just about an employee being sick under these laws, but having the ability to take these paid days to care for a sick family member, or like Josh mentioned, to cover other safe time. Things and items that may not be provided for in a CBA on these particular issues. The next one is notice. Right, a lot of these laws require little or no advance notice to use these paid sick days, and in some instances, CBAs require advance notice to use the time. How is this time accrued, and whether you have to wait to use it? Most of the laws set earning and usage requirements that may be different than what the CBA provides, particularly as it relates to probationary employees, where generally speaking, in a lot of contracts, probationary employees have to wait a certain amount of days in order to be entitled to a certain amount of benefits. It also has impacts on other provisions, the seniority provision, the bumping provision, the scheduling provision of the CBA. Also, attendance system, use of point systems that assign any points for sick days that are prohibited by the law can be viewed as retaliatory, even if permitted under the CBA. The next one is rates of pay. What rate of pay does the law require the sick day be paid at, and how does that compare to what's in the CBA? Another important one, documentation. Generally speaking, these laws limit circumstances in which an employer may require documentation. And a lot of CBAs often provide that you have to provide certain medical documentation in order to substantiate or in order to take a sick day. And the last one being notice, posting, and obligations, right? You have to distribute these laws and post these laws for employees. Again, something that maybe, parties to a CBA are not accustomed to doing. Next slide, please.
I just want to chime in here, Jason, that the prior slide identifies the very same conflicts that air and rail is facing in their collective bargaining agreement. So that's not unique there. Those are the pain points really that we've seen in those areas.
Yeah, it's a really good point, Ada. Next slide, please. So now that we talked about some issues that complicate paid sick leave law and some items that may be in conflict in those laws with CBAs, let's practically talk about, what are the steps that we should be doing to undertake to deal with these laws? And I've provided 6 steps here. The first is the most basic, right? Does my unionized workforce work in a jurisdiction that has a paid sick leave law? If it does, are there exceptions to the law that apply? Are there industry exceptions? Are there specific employee exceptions? Are there CBA exceptions? A lot of them we've discussed. The third is, and we've discussed this as well, and we'll talk about it in New York and New Jersey. If I have a CBA that is currently in effect at the time one of these laws become effective, do I have to immediately comply with it, or am I allowed to wait till my CBA expires in order to address it? The fourth one, and probably the most important for everybody on this call, can I waive the law in my collective bargaining agreement? And if I can waive the law, what does that mean? How do I correctly do so? What do I need to provide in order to accurately and correctly waive the law? And finally, if you're in a jurisdiction where you can't waive the law, what does that mean in terms of a unionized workforce? And that really means getting compliance, which means you have to work with the union, over the same, providing notice and an opportunity to bargain. Next slide, please. So now that we've kind of laid out the steps we should take when we're evaluating whether this law applies to our unionized workforce, let's see how it plays out in New York and New Jersey. And the first one we're going to cover is New York State paid sick leave, right? So we're going to look at the law and see who it applies to and whether there's any exceptions or exemptions. And in New York State paid sick leave law, it applies to all private sector employees in New York, regardless of industry, occupation, or part-time status. So in other words, there are no industry exemptions or employee-specific exceptions. As far as when do we have to effectively follow the law. And you'll see the theme here with both New York City, and New Jersey is if you had a CBA in effect at the time or the date that the law became effective, you don't have to comply with that law until the CBA expires. What does compliance look like in New York State paid sick leave law? Really easy, right? The leave policy must meet or exceed the accrual, carryover, and use requirements laid out in the law. And is waiver permitted in New York State? Yes, it is. And an express waiver is permitted, and you have to do two things in order to do so. You have to, one, specifically acknowledge you're waiving Section 196B of the labor law. So you have to specifically cite to that particular law. And you also have to provide that you provide comparable benefits. Now, when the law first came out, a lot of questions arose as to what that really meant. And since that time, we've gotten some clarification from the DOL in that regard. And they consider leave time which has fewer restrictions on its use to be comparable to that's required by the law, regardless of how we label that leave, whether it's annual leave or vacation time. And it also allows an employer to look at multiple different leave benefits and combine those to meet the requirements of the use requirements. So you can combine those particular different types of leave in order to get to that final number of what's required under New York. And in that regard, you have a comparable benefit. The DOL in this regard recommends parties to a collective bargaining agreement who are governed by this particular law to provide what those comparable benefits are in the CBA, although there's not any express requirement to do so. And lastly, who could file a complaint under this particular law with the DOL? It could either be a union or an employee. Next slide, please. Now we're going to look at the New York City aspect of it, and we're going to go through the same analysis. So we're going to look to the law, right? Who does it apply to and whether there are any exemptions or exclusions? And this applies to all private, nonprofit, and household employers that employ workers in New York City. There are certain industry exceptions and exclusions of particular types of employees. So if you fall within that bucket, you could be potentially excluded from the law. As far as the effective date impact, much like New York, if you had a CBA in effect prior to the effective date of the law, you don't have to comply with it until expiration of your collective bargaining agreement, whereby you could deal with it in subsequent successor negotiations. As far as compliance, it's kind of very similar to New York State, right? The leave policy must exceed or meet the requirements of the Act. And much like its New York State counterpart, waiver is also permitted. You have to expressly provide that you're waiving the law, although unlike the New York State counterpart, you don't have to cite to a specific legal section. And you also have to provide comparable benefits, like its New York State counterpart. And when this law first came out, again, a lot of questions arose as to what that meant. And since that time, we've also gotten clarification from the city. They view comparable benefits to include, but not be limited to, vacation time, personal time, safe and sick time, holiday time, and Sunday time at premium rates. So that would be what is considered comparable benefits under that particular law. And much like its New York State counterpart, unions and or employees can file a complaint alleging non-compliance with the law. The New York City and New York State law are very similar, but they're not identical. So, to the extent that anybody has any questions about the differences and similarities, you should consult with your legal advisor with regard to any specific questions. And then the next slide, please. Last one we're going to focus on is New Jersey, and it's similar to New York, but it's also very different to New York. Again, let's look to the law to see who it applies to. All private sector employees with employees in New Jersey. Also allows exclusions for certain industries, construction industry, as well as certain types of employees. The effective date impact, very much the same as New York, whereas if you had a CBA in effect at the time the law became effective, you didn't have to deal with the CBA until your CBA expired. The biggest difference between New Jersey and New York, even though is that while it permits a waiver, the biggest difference is that New Jersey doesn't impose any requirement to offer similar, comparable, or identical benefits. So essentially, New Jersey leaves it to the employer and the union to bargain this topic. And whatever comes of that bargaining is memorialized into the collective bargaining agreement, and that's what applies. There's no restrictions, there's no requirements to do something that's similar, comparable, or even identical. And as that commentary from the DOL confirms, you can even provide less favorable terms if that's the agreement that the employer and the union have reached. And much like its New York counterparts, again, a union and or an employee can file for noncompliance. Next slide, please. So in contrast to the legal challenges that are apparent in the rail and airspace, and Ada will get to that shortly, we just have not seen that many public sector reports or complaints or related litigation initiated by a union or a union represented employer alleging noncompliance with the sick leave law. And I think that's for two primary reasons. A lot of these CBAs provide the requisite number of required days, and the other is unions and employers are working together to address this issue however that plays out, whether that's a waiver or having to change certain mechanisms and procedures in how you administer your sick leave in order to comply with the law. I don't necessarily think that means that this is a low risk area. I just think it means that to date, employers and unions have been able to work together with regard to the implementation of these laws. Now, that said, if future laws come out that make compliance more difficult or add a significant economic component to the law that employers are going to have to meet in order to comply, then we may start to see an increase in complaints and noncompliance and then related litigation. And we're just going to, next slide, and then could you just skip this slide for me, Kate, the next one, go to the next one. Thank you. And we're gonna end here with some best practices here. What should you be doing? What are some best practices and how to address this? And the first is we want to develop a plan to timely enact these required changes, right? Do I have to comply? When do I have to comply by? Can I waive it? What does that waiver look like? You should start focusing on these particular items. Work with unions to secure buy-in. I think in this particular issue, you have to view them as a partner here. This is a mandatory subject of bargaining, and certain requirements have been imposed on the parties by the state, and it's incumbent on the parties to work together to address them in an effort to reach an agreement that both sides can accept. And if you're the employer and it comes with an economic cost, I think the question that you have to ask yourself is, are you going to look to seek and recoup that economic cost in some way, shape, or form elsewhere in the collective bargaining agreement? Of course, you want to train your supervisors and HR reps in the proper administration of these laws. And finally, you want to communicate what your sick leave and safe law policy is to your employees. That should be done in a single document. It could be in an article of a CBA. It could be an appendix, an exhibit, a side letter, or reference to a policy in the employee handbook. It should clearly spell out how the employer calculates sick leave, the types of sick leave reasons that it could be used, as well as the carryover procedures. And if you are in a jurisdiction that allows you to waive it and provide comparable benefits, it's advisable to spell out what those exact comparable benefits are. And then finally, like all other policies that an employer has, you just want to make sure that you're administering it uniformly. And with that, I'm going to turn it over to Ada.
Thank you. And I think Kate at this point has a CLE code.
At this time, we will read the CLE code for today's program. Please write this code down as it will not be reread. The CLE code for this webinar is SS, as in Seyfarth Shaw, 7153. Once again, the code is SS, as in Seyfarth Shaw, 7153.
Thank you. Kate, if you can go ahead to slide 36, I'm going to jump ahead a little bit here based on timing and probably go back. But what I wanted to address is what Josh was referring to earlier, that paid sick leave has been making the headlines with respect to the rail labor dispute that's been going on. And up to the minute updates from us here, the House passed a bill requiring the enforcement of the agreement that was recommended. There is a separate portion that they're going to hold a separate vote on for amending the act, or amending the agreement rather, to add 7 additional sick days. So they're holding separate votes on that because they're not sure if the Senate will go along. So next up is the Senate, and there are interests certainly in this time of year in making sure that rail doesn't shut down. The other issue is, because of the regulations, rail would have to start deciding this week on closing down or shutting down certain transportation that it does would do next week. So this is having a significant impact, and it really has paid sick leave at the forefront of this discussion here. So I wanted to make sure I gave us an update on that. If you can go back now to my first slide. Okay. All right, so AIR is somewhat unique from some of the employees that Jason was talking about. They have even more problems, I would say, or issues trying to comply with multi-state types of paid sick requirements. So one thing that's interesting is pilots and flight attendants spend the bulk of their time working in federal airspace, federal or international airspace. There was one study that was presented in litigation where the flight attendants involved spent, 60% of their time in the air, another 20% of their time on the ground, and then a very small portion of that time in the city that was imposing the paid sick leave requirement. So these are some reasons why air and rail, and particularly air here, have a difficult time complying. Next slide, please. And more reasons, I guess, why it's problematic for air here is there are certain standards that have been routine in these collective bargaining agreements, and they're very much attuned to the way airlines need to run. For example, the prior slide had something about, how much advance notice is required. We have a judge saying to the airlines that 1 hour advance notice is sufficient time to locate another flight attendant. And that has been challenged in other litigation as well. But some of the assumptions that are made about how this will work in practice are simply not consistent with the facts. Okay. And particularly a standard usage in the air and rail is a points attendance policy. And here, if you award different points based on the amount of advance time, there are different points assessed, and many of these municipalities and states are saying that that is retaliation. Next slide, please. This one mirrors one we saw earlier. So this is the one Jason talked about, where we start to see these conflicts coming out, particularly in the last few years with the patchwork of paid sick leave. Next slide, please. What's unique, I think, to air and potentially rail has sort of a whole different preemption scheme where they are on pretty solid ground in finding that a federal law covers and includes sick leave. So they've had more success on the rail side in arguing that they need this consistent policy across the country. For that reason, we've had some legal challenges. I'll talk about just a few of them, challenging Massachusetts, New York, and Washington State. The Massachusetts sick time law is currently, or was recently, it may have concluded, on trial, and evidence was being presented about both sides in front of a judge. So that did not succeed in being dismissed as a matter of law, and now they're digging into the underlying facts, likely to explore whether there's a substantial impact of these changes on the airline. New York City's earned sick time law, that's the one I referenced earlier, where we actually had a win for air, which is a situation in which the court found that the city paid sick leave law was preempted by the Airline Deregulation Act, not the Americans with Disabilities Act. The Washington paid sick leave law, this has not been as favorable, I'll say, for airlines. And if there was an opportunity for the ruling that found that the paid sick leave requirements were not preempted by the Airline Deregulation Act, there was an opportunity for the Supreme Court to take a look at this issue, and it declined. So we have some pretty onerous case law that is binding in the Ninth Circuit on these points. Next slide, please. Next slide. I just want to make one quick point on this slide here. There was a lot of advocacy around paid sick leave before we had COVID, but certainly the COVID-19 epidemic has dramatically impacted and shown a light on the paid sick leave requirements in a way that I think is unprecedented. So this has not been sort of helpful when you're trying to comply with this patchwork of state laws. Next slide, please. There's multiple grounds on which the airlines and airlines are challenging the paid sick leave laws that they're being required to apply with. The first primary ground of challenge is something called the dormant commerce clause. This is a situation where the law is assumed to prohibit certain state level activity. So it's an interesting sort of theory that has been established and has been upheld in similar situations, but so far has not been making traction lately. Next slide, please. There's also the 14th Amendment's due process clause. The argument that a state is not permitted to enact a law that applies extraterritorially. Judges have been very dismissive of this argument and said, well, just comply with the most strict state. And that is in effect applying a state's law outside their boundaries. So arguing back, airlines have been arguing that this is in effect a violation of the 14th Amendment's due process clause. Next slide, please. And the one that's been more successful is the Federal Airline Deregulation Act. This act preempts any state law related to a price, route, or service of an air carrier. And the litigation has focused on what does related to mean? What does service mean? So there's been a number of precedents in the past that seem to take a more lenient view or broad view of what would impact a price, route, or service of an air carrier. So the primary Supreme Court case that is relied on here is Morales. And in that case, the Supreme Court held that state laws are preempted if they have a significant impact on carrier prices, routes, or services, even if that impact is only indirect. And arguably, the Ninth Circuit came out with a much more narrow view of preemption, in which it ruled that only those laws that bind an airline to a particular price, route, or service would be preempted. And because this is a statute of general applicability and the airline was not targeted, that it would not be covered by these preemption grounds. Next slide, please. Here are some comments pointed out from the successful challenge to the New York City paid sick leave that show the types of things that were considered by the court. And next slide. So hopefully you're not waiting for me to come to the end of this with a grand solution for airlines. We see ahead of us continued compliance issues and continued lawsuits. And at some point, just as we've seen some cooperation under the NLRA, we are going to have to see cooperation with RLA employees as well, because it's simply impossible to comply in some ways with a flight attendant or pilot who flies through 2 states, stops in one. You have to do potentially a choice of law test to try to understand what the paid sick leave would be. And it's just simply not feasible. And with that, I'm going to pass it back to Josh.
Great, thanks, Ada. Thanks so much. Couple of very quick outlook and resource slides for you all. I know we're at the top of the hour, so just go power through these. First, we have a slide that shows the paid sick leave outlook for 2023 and beyond. New York City is undergoing some significant amendments to its sick leave rules, and there are amendments in Michigan that are scheduled to go into effect in mid-February. Those are really the two big ones that a lot of folks are paying attention to. We've got, in terms of next locations likely to adopt, Minnesota came really close last year to passing a statewide paid sick leave law. Delaware just passed a statewide paid family leave law. So we're expecting one, maybe both of those states. Illinois is another one that's always hovering out there. From a municipal level, we're waiting to see what might happen with the jurisdictions that just had their COVID paid leave laws on the books and sunset recently. Are they going to start passing public health emergency leave laws like we see in Colorado and San Francisco? Next slide, please. Some resources. We have a great comprehensive by subscription paid sick leave survey that covers all sick leave, COVID, non-COVID, PTO laws that we've talked about today. You can email us if you have any questions or want more information. We have a paid sick leave mailing list that you can sign up for. It takes about 1 minute. Then you can get access to all of our client alerts and legal updates and blog posts as we put those out there on sick leave developments. On the next slide, you will see this webinar series, right? Again, part 9 today. All of the prior parts and today's part have great information for you all on the messy sick leave patchwork. And we have a Take It or Leave It podcast that I'm very happy to be one of the 2 co-hosts of that is turning a year old this month, well, next month, I guess, in December. We have over a dozen episodes that we've put out on a wide variety of workplace leave absence management and accommodation topics. Please tune in. It's available where all your normal podcast episodes are streaming. Next slide, please. We have a great labor law team at Seyfarth, dozens of experts scattered all over the country, some who've worked for the NLRB. You can get more information about our team and our related employer labor relations blog on this slide. And then finally, on our next slide, you will see our amazing air and rail team, which Ada is one of the co-leads of, along with our partner, Molly Gable, dedicated specifically to the nuances, as you've heard today, that impact the air and rail industries. And with that, thank you everyone for joining us. We really appreciate your time. Hope everybody has a nice holiday season, and thank you so much.
Thank you to all of our presenters. This concludes today's webinar. Thank you for attending.